I decided to do my project on intellectual property, and the three of the more common types of intellectual property that you might come across there: copyrights, patents, and trademarks. So, what is intellectual property? It is the creation of the mind rather than a physical product. And this type of property is governed by certain laws because, unlike, let's say, if I built a desk, I could choose to either keep that desk or sell it to somebody. And it's kind of cut and dry if I have the desk or if somebody else has it and has my permission to use it. Intellectual property is a little different um, since there's nothing of physical of value. It's a creation of the mind. So this type of property is protected by copyrights, patents, and trademarks. And these protections enable the creators of the intellectual property to profit from their creations. And the first type that we'll look at is copyright. And copyright is easily defined as the right to copy. And it pertains to literary and artistic works, protects things such as books, songs, paintings, computer programs, maps, movies, scripts, all sorts of things like that. And in order to use a person's copyrighted material, you must obtain a license to use it. Copyright law, as we'll see with all these types of intellectual property, the laws vary between countries, obviously. But according to the US copyright law, your idea is your copyright the moment it is expressed in a tangible form, i.e., something written down. So if you have an idea for a song or a book in your head, that's not copyrighted until you express it in a tangible form, whether it's writing it down on a piece of paper or on your computer or recording it or whatever. It has to be expressed in a tangible form, and once it is expressed in a tangible form, then you have the copyright for that. However, in order to prove that you had the idea first, should somebody else claim it, it's best to register the copyright with the government. And in the US, a copyright lasts for about 70 years from the author's death. And these weren't always the laws. For instance, for a while, the law was that something wasn't copyright protected unless you actually had the copyright information on it. And one famous example of this is the 1960s movie Night of the Living Dead is actually public domain, even though the writer and director of the movie is still alive and well. On the very final edition of the movie that was shown in theaters, they forgot to include the copyright information on it. And since they forgot to do that, the laws at that time stated that the movie was then public domain. The laws have since changed, and you don't need to have the copyright information. It's always good to, because it helps prove that you had the idea first, should somebody challenge that. Copyright and publishers. Many authors assign their copyrights to publishers in order to best exploit their works, and exploit usually has a negative connotation, but in this case it just means get the most out of the work, have the most opportunity for their work to make money. And so publishers will often register the copyrights in their own name and then split any profits from the copyright between the publisher and the author according to what the contract says. And it used to be the law, again, that copyrights needed to be renewed, I think, after about 25 years. That is no longer the case. You no longer have to renew copyrights. But in order to protect let's say an author giving their copyright to a publisher, and the publisher really not doing anything with that copyright, the government, in order to protect from that, stipulated in the new law that 35 years after the copyright date, an author has a 5-year period in which to get his copyright back, and he has to notify the publisher in a certain way, and all these things. And that came up a lot recently because the law went into effect in 1978, and so that 35-year period recently took place in 2013, and a lot of it was in the news a lot. Bands from the 1970s were looking to get the copyrights back on the albums that they made in the late 70s because you know, people already knew the albums, people already liked the albums, and they didn't really want to split the proceeds anymore with the publishers. They wanted to self-publish the albums and make more money that way. Copyright infringement can carry large financial penalties and even jail time. And infringement can include the copying, quoting, or public performing of someone else's copyright. And one big example of this is why restaurants, if you go to a big restaurant, they don't sing happy birthday to their patrons. They do their own little song, and that's because the happy birthday song is actually copyright protected. Even though I looked into it and I think it's a rather it really shouldn't be. They kind of copyrighted it on a technicality, but it's copyright protected, and so if anybody performs it publicly, like in a restaurant setting, then they can be charged with infringement if they didn't pay for it. There are many different organizations that kind of help people license to correctly license a copyright, and you can also go to the publishers if you know who they are. And another thing is many things can be copyrighted by 2 or more copyrights, or protected by 2 or more copyrights, and you have to have permission for all copyrights in order to use the work. So for example, if somebody wanted to put a Bob Dylan song in their movie, they would not only need the copyright of the record company that released the record, but they would also need the copyright of the publishing company that controls the lyrics and the music. So the record company really controls the sound recording, and the publishing company controls the lyrics and the music. And unless you get the copyright permission from both of them, then you would be infringing on somebody's copyright. The next type we will look at is patents. And a patent is an exclusive right for an invention, be it a product, process, or technical solution to a problem. It's like a copyright, and that it's protecting, an intellectual property. But in exchange for a patent, the details of a person's invention become publicly available. So once you register your patent, that patent is publicly available for anybody to look at and improve upon if they wish. So let's say, for example, you have a patent for an invention that you have, and somebody looks at that patent and says, you know what, I can improve that invention, and invents a process to improve that. They can register their own patent for the process that they came up with, but to do anything with that, they also need to license the patent for your original invention. So yes, if somebody wants to use your patent, they must obtain a license from the patent holder. And again, like all these others, a patent law varies by country, and a patent, unlike copyright, where pretty much if you copyright something in your country, it's copyrighted around the world. It's not technically the case, but it's copyrighted in most countries around the world. A patent is territorial, meaning it only applies to the country or territory in which the patent is registered. And so in order to protect your patent throughout the world, you need to register it in every territory throughout the world. And there are some territories that combine, like I think some European and African territories will have a combined patent law to make things a little easier. In the U.S., patents generally last for about 20 years from the registration date, but in order to keep the patent, the applicant must pay a maintenance fee, which is, you have to pay one fee 3 to 3.5 years after the patent date, then after 7 to 7.5 years after the patent date, and then between 11 and 11.5 years after the patent date. And if you do not keep up with those, then your patent becomes public domain. So it's kind of like how I mentioned with copyrights, how you used to have to renew them. Patents you kind of have to renew in certain time frame. And then trademarks. Trademark is a sign, design, or expression that is used to identify products to a particular source or company. And it can be a word or combination of words, combinations of letters or numbers, drawings or symbols. Those are usually the trademarks that we're more familiar with. It can also be three-dimensional figures. For example, the packaging of a product could be a trademark if it's something unique to your company. And fragrances and sounds can also be trademarks. And like copyrights and patents, trademarks protect the right of of whoever came up with it to use the registered work, and can be licensed by others. And one notable example of this type of thing is something like Star Wars Monopoly, where Monopoly will license the Star Wars trademark and the trademark of individual characters and things like that in order to sell a Star Wars Monopoly game. And, it benefits both companies because Star Wars is making money off of it and Monopoly is having a unique game to offer. And licensing of trademarks also protects companies because they can choose whom they want to license their product to, and if they feel that this company or whatever does not mesh with their values or ethics, they can choose not to license their trademark, and so it kind of protects the company brand that way. Trademarks only apply to the territories that they're registered in, like patents. There is a kind of way around this, and actually a lot of the information that I got for this presentation was found on the, I think, World Intellectual Property Organization, I believe is the title. It's WIPO.INT, and that has a lot of information about different types of intellectual property. And they did mention one way that trademarks can be registered in multiple countries with one trademark, but it's kind of a special thing that they came up with. In the US, trademarks usually last for about 10 years, but can be renewed indefinitely. So again, it's something that you have to keep renewing. And the government may refuse trademarks for various reasons, including something that's merely descriptive or misdescriptive. Something that's merely descriptive might be the use of the word denim in a trademark for jeans, because it's kind of describing the jeans. So that wouldn't be trademarked. Something that's immoral or deceptive, if the government finds it immoral or vulgar or whatever, they can refuse the trademark. Something that falsely suggests a connection. For example, if I were to trademark a fragrance and I called it Eau de Elvis or something like that, the government would not recognize that trademark unless I had permission from Elvis's estate to use his name in connection with that trademark. If I did not have permission, then they would not recognize it because I'm falsely connecting with Elvis. Or if a trademark can cause confusion with another registered trademark. And that, something like that is brought up on the next slide with different trademark cases. And one big case about trademark was Apple Corps versus Apple Inc. Apple Corps is the record label that the Beatles came up with, and Apple Inc. is the company that produces the computers and the iPods and all those things. And they had many disputes between the 70s and the 2000s. Basically, it started with Apple Corps saying that Apple Inc. cannot venture into the recorded music field, or else it could cause confusion between the two brands. And Apple Inc., the judges ordered in favor of that, but then through the years, Apple Inc. Came out with computers that specialized in recording music, and Apple Corps sued them because they were like, it's in the recorded music field. Or Apple Inc. would try to trademark different sounds for their computers, and Apple Corps would come after them again. And it really all came to a head in the 2000s when Apple Inc. released the iTunes program, and Apple Corps came after them and said, this is obviously entering the recorded music field, and we feel that you can confuse people between our product and what you're offering. And the U.S. court actually ruled against Apple Corps, and they said that they didn't think that there would be a lot of confusion. But there were still heated things back and forth until finally in 2007, they decided that Apple Inc. would buy the trademark from Apple Corps for I think about like $500 million or something like that. And basically now they license it back to the Beatles, and that seemed to make all sides happy. Another trademark case that kind of points to confusion between brands is Mattel versus MCA Records. In this case, Mattel sued MCA for the song Barbie Girl, claiming that it violated their copyright and also tarnished Barbie's reputation, which I'm guessing is a good reputation. Or Mattel thought so, at least. And the case was dismissed by the court, and they ruled it that the song was a parody and therefore subject under fair use. Which is an interesting thing about intellectual property, is that there are certain cases of fair use. One case is for educational purposes. For example, I can use different people's trademarks in a presentation like this because it's an educational purpose. I'm not trying to in any way profit from their trademark or anything like that. I'm just using it to discuss the company in an educational way. Another fair use term would be if you have a movie or a CD and you wanted to make your own private copy for kind of safeguarding should something happen to the original, you still have another copy. That is considered fair use. Another type of fair use, as mentioned in the Mattel case, is parody. The rules for that are fairly strict. A famous example is Weird Al. Technically, he doesn't have to get permission for his parody songs because they're parody, but he does anyway because he wants to be a stand-up guy, which is pretty good. Another term of fair use in the music field, which is what I'm familiar with, that I kind of find interesting, is that the law states that once you, it's not really fair use, but once you record a song and make it available to the public, anybody else who hears that song can record your same song and sell it as well, providing that they pay you a statutory rate that the government has set up. Right now it is 9.1 cents per use, which is not very much. So you could do 100 copies of that person's song and only have to pay $9.10. But I find that interesting in that the government says once you put it out there and record it, anybody else who wants to record it and sell it can. They can't make arrangements of it, they can't do some other things to it, but they can record it and sell it once you have recorded it and offered it for sale. So that is a basic introduction to different types of intellectual property, and I find these things interesting because, like I said before, it's not something tangible that's there in front of you that you can kind of say, this is mine, it's not yours. But since it's a creation of the mind, the government has come up with different ways to protect that so that you can profit on these creations. And I think that's good. Thank you.